I say a marriage fraud finding or 204C finding is the kiss of death in immigration, because it prevents you, if you have such a finding, from being the beneficiary of another approved petition for an immigrant visa. A marriage fraud finding or 204C finding is not something that can be arbitrarily done. There must be substantive and probative evidence in the immigration file of this marriage fraud. Because the consequences of marriage fraud are so severe, the evidence that must be in the file for such a finding has to be substantial and probative evidence. There are ways that you can fight a marriage fraud finding if the evidence in the file is not substantial and not probative. Typically, these cases can be appealed to USCIS and then to the BIA, and then if there is no solution there, they can be fought in district court, which typically is what happens and where there is some sort of resolution for these cases. Marriage fraud is a huge issue, a big problem, but there may be cases where the petitioner and the beneficiary are filing for your green card based on a marriage, but you may not have a lot of evidence to support your case, although you do have a bona fide marriage. In cases like that, or in cases where maybe you have a notice of intent to deny, or you do have a marriage fraud finding, you really should contact an immigration attorney to get some help and consultation with it. All right, guys. Well, thanks for watching. Be sure to like, follow, subscribe, and share for more immigration tips.